Hi there, welcome to Help Solve the Case. Today we are continuing our review of the Pamela Smart request for habeas relief. Now, Pamela, if you don't know, was charged with a conspiracy, including her 15-year-old student, to murder her husband. And this was back in the 90s. And they are talking about all kinds of very interesting things that, although this case was a while ago, it is very interesting today. If you don't know me already, my name is Christine Burke. Welcome to Help Solve the Case. I'm a retired police detective and sergeant, current law enforcement policies and procedures expert, and private investigator, and I love everything court related. Talking about how we can prepare cases better, how we can evaluate cases better, and we can all learn about the criminal justice system. Thank you for being here. We're going to continue here with our review. So we were talking here about the statement of facts. Hopefully you can see that fairly well. All right. And it says the statement of facts in this case are quite extensive and a detailed summary is not possible. For purposes of providing the necessary facts, let me make sure I am in the right area here. There we go. Try to get out of the way. For the purposes of providing the necessary facts for an understanding of the relevant issues in a neutral manner, this is a defense pleading, Ms. Smart recites the statement of facts as summarized by the Supreme Court of New Hampshire in Ms. Smart's direct appeal. Okay, so this is not her first shot at this. And as we talked about yesterday in part one, she's being held in New York, even though she was tried and convicted in New Hampshire through the interstate compact. It's all kinds of crazy. And where this was filed, it was heard. She's in New York. It was heard in New Hampshire. They did oral arguments 2 days ago, and it's all kind of a mess potentially with jurisdiction. So we're going to see what happens. Okay. But they already talked about a lot of things and tried to get this case moving previously and were unsuccessful. They even heard it before the judge that heard the first trial. So they were kind of complaining against the first judge, complaining to the first judge about what he or she did. Okay, so that probably didn't work out too well. All right, it says they are using this as a summary, not a concession. So they're not agreeing to it, but they're talking about the court provided. This is the court's facts. The defendant, Pamela Smart, upon entering her Derry home on the night of May 1st, 1990, observed the body of her husband, apparently the victim of a homicide. The police arrived on the scene shortly thereafter and immediately commenced a murder investigation, culminating in the defendant's arrest. After a jury trial in Superior Court, the defendant was convicted of accomplice to first-degree murder, conspiracy to commit murder, and tampering with a witness. Viewing the evidence presented at trial in the light most favorable to the state, the jury was warranted in finding the facts as set forth in this opinion. They're stating court opinion, court facts. In the fall of 1989, the 22-year-old married defendant was the director of media services for the school district that included Winnicott High School in Hampton. She met and befriended William Flynn and Cecilia Pierce, two 15-year-old high school students from Seabrook, and they and other students worked together after school hours to produce an orange juice commercial for a contest. Eventually, in February or March of 1990, the defendant and Flynn became sexually involved. Shortly after their affair began, the defendant told Flynn that in order for them to continue their relationship, they would have to kill her husband, Gregory, a 24-year-old insurance salesman to whom the defendant had been married less than a year. Eventually, the defendant and Flynn together planned that Flynn would commit the murder with the help of his friends and would stage the killing as if committed in the course of a burglary of the defendant's home. According to the plan devised by the defendant, She would leave open the bulkhead door to the basement of her home to provide entry for Flynn and the others before Gregory returned home. The perpetrators were to park their car in a shopping center behind the residence and change into dark clothes before approaching the apartment. The defendant advised Flynn that he and his accomplices should wear gloves to avoid leaving fingerprints and should ransack the apartment, taking away whatever they wanted as compensation. Pursuant to the defendant's plan, her husband was to be killed with a gun upon entering his home as if he had surprised the burglars. Flynn discussed this plan with his friends Pete Randall and Vance Latomy Jr., also teenagers from Seabrook. With the aid of another boy, Raymond Fowler, Flynn set out from Hampton to commit the murder one night in April using the defendant's car. When the two arrived at the defendant's apartment complex, however, they saw her husband's truck and abandoned the plan. After this unsuccessful attempt, Flynn recruited Randall and Latomy to help execute the plan. He told them that the defendant had agreed to pay them $500 each for committing the murder. Latomy provided his father's .38 caliber revolver and his grandmother's car to transport the boys from Seabrook to the defendant's Derry apartment. After school ended on May 1st, 1990, the defendant drove Flynn, Randall, and Latomy to pick up Latomy's grandmother's car in Massachusetts. The defendant discussed with them various details of the murder plan, seeking advice on how to react when she returned home and discovered her husband murdered. Latomy and Randall returned to Seabrook in Latomy's grandmother's car. The defendant drove Flynn back to Seabrook to meet them and then went to Winnacunnet High School to attend a meeting scheduled for that evening. Flynn, Randall, and Latomy picked up Fowler and drove to the defendant's residence. While Latomy and Fowler waited with the car at the shopping center, Flynn and Randall entered the defendant's apartment through the unlocked bulkhead in the basement. After ransacking both the upstairs and downstairs of the apartment, they waited for Gregory to return home, with Flynn carrying the gun and Randall holding a knife he had taken from the kitchen. When Gregory came home, the boys forced him to his knees. While Randall, with one hand, held Gregory's head down, and with the other hand held a knife in front of his face, Flynn shot him once in the head. Taking a pillowcase they had filled with jewelry, the boys fled to meet Fowler and Latomy, and the four drove back to Seabrook. The next day, Latomy replaced the gun among the rest of his father's collection. On June 10th, Ralph Welch, a friend of Latomy, told Latomy's parents that Randall and Latomy admitted to him their participation in the murder. Latomy's parents took the gun to the Seabrook Police Department, accompanied by Welch, and subsequent ballistics tests confirmed that the gun had been used in the murder. Worried because of Welch's intention to go to the police, Randall and Latomy went to see Flynn and the defendant at the latter's new condominium in Hampton. After discussing the matter, the defendant drove them to Seabrook in an unsuccessful attempt to retrieve the gun. The next night, June 11th, Latomy, Randall, and Flynn were arrested. Virtually daily before May 1st, the defendant spoke with Cecilia Pierce, her student intern, about the plan to have Flynn murder her husband. The night before the boys were arrested, the defendant told Pierce of Welch's intention to report the boys to the police and said that if Latomy and Randall were smart, they would blame Welch and Fowler for the murder. Pierce was questioned several times about the murder by the Derry police and denied any knowledge of it. On June 14th, after hearing rumors of the impending arrest of an unidentified girl alleged to be involved, Pierce again met with the Derry police and told them of the defendant's involvement in the murder. She agreed to a phone tap of a conversation with the defendant and to wear a recording device or body wire to record face-to-face conversations with the defendant. On July 12th and 13th, with Pierce surreptitiously recording their conversation, the defendant warned Pierce that if Pierce told the truth to the police, Pierce would be an accessory to murder and urged her to continue to lie. The defendant acknowledged that the boys had carried out the murder to look like a burglary as she had planned and stated that, quote, nothing was going wrong, end quote, until the boys told Welch about it. She stated that if arrested, she would admit to the affair with Flynn, but deny any involvement in the murder plot. She expressed concern that Latomy, who merely waited in the car during the murder, would eventually confess and implicate the others. Nevertheless, the defendant told Pierce she was confident that, as between a 16-year-old, quote, in the slammer facing the rest of his life, end quote, and herself, quote, with a professional reputation and a course that I teach, end quote, her denial would be believed. The defendant reminded Pierce that by telling the truth, Pierce would be sending the defendant to prison for the rest of her life. On August 1st, 1990, the defendant was arrested in connection with the murder of her husband. In January 1991, Flynn, Randall, and Latimer agreed to plead guilty to reduced charges and subsequently testified for the state at the defendant's trial. Another witness, Cindy Butt, a co-worker of Pierce, testified that a month prior to the murder, Pierce told her that she had a, quote, friend named Pam who wanted to find somebody to kill her husband, end quote. George Moses, a high school student, testified that he knew the defendant at Winnicott High School and met her again while visiting his mother in prison. According to Moses, the defendant asked him to lie for her by claiming he had overheard Pierce admit to lying to the police about the defendant's involvement. That's a little confusing. Okay, the jury found the defendant guilty of all charges. It says additional facts will be introduced where relevant. It talks about here subsection 3, and this was something we discussed in one of the counts yesterday or in the first recording, that they're talking about the distortion of this court recording, this transcription that was given to the jury. And so that's why I think that they're including here. They say that Ms. Smart has a right to file a petition for habeas corpus. Quote, when court action results in the loss of a constitutionally protected liberty interest, it may be collaterally attacked by way of petition for writ of habeas corpus after the time for direct appeal has expired, end quote. And they quote State versus Kinney, quoting Sleeper v. Warden, New Hampshire State Prison. Thus, a writ of habeas corpus, quote, provides a remedy for constitutional errors, without limit of time, end quote. They quote Mallard v. Warden, New Hampshire State Prison, says the important principle is that a prisoner, quote, establish a harmful constitutional error, end quote. And they cite Humphrey v. Cunningham. And that's what we talk about. We talked about that there was foundational error in this case. Okay, the basis on what our justice system is created from, and that is the Constitution, right? In New Hampshire, a second habeas corpus petition is not procedurally barred if the issues raised in the second petition are different from the issues raised in the first. The matter of subsequent post-conviction filings was reviewed in Mallard v. Warden, New Hampshire State Prison. Mallard filed a motion for new trial and then a habeas petition, both asserting ineffective assistance of trial counsel. Quote, the issue in the motion for a new trial was whether Mallard's trial counsel was ineffective for failing to object to a curative instruction and for failing to cross-examine the victim about certain text messages, while the issue in his habeas petition was whether his trial counsel was ineffective for referring to him as a, quote, big menacing black guy, end quote. The court held against the state's protestation that, quote, even if Mallard's motion for a new trial were treated as the equivalent of a petition for a writ of habeas corpus, making this his second habeas petition, the second petition is not procedurally barred as the issues raised in the two pleadings are different, end quote. The court allowed Mallard to raise ineffective assistance of counsel in both petitions when the second filing raised a different question. Now, in the court system, people get sick of repeated attempts for a new trial, and it goes on and on and on, although that is a fundamental right. There are limits, it sounds like, on how many you can file and what you can file on. What they're stating here is because Ms. Smart has already filed one. What's talking here, we've got a subsection here. The right to file a petition for habeas corpus is statutorily provided as, quote, a person imprisoned or otherwise restrained of his personal liberty by an officer or other person, except in the cases mentioned in the following section, is entitled of right to a writ of habeas corpus according to the provisions of this chapter, end quote. They're talking here about Mallard again. It says it relied on the court's previous holding in Gobin v. Hancock that the doctrine of res judicata does not apply to habeas corpus proceedings. The petitioner in Gobin filed 3 other petitions for a writ of habeas corpus in the same matter. The court made clear that a, quote, refusal to grant a writ of habeas corpus or a dismissal of one is not res judicata on a subsequent application for such a writ, end quote. Both Mallard and Gobin referenced Petition of Mobus, which stated that, quote, repeated applications for a writ of habeas corpus introducing no new facts material to the issue will ordinarily be summarily disposed of, end quote. Both Mallard and Gobin then implemented the supposition that where a writ of habeas corpus does introduce new facts material to the issues in the case, a petition is properly brought before this court. So they're trying to establish, look, we have a right here. They're also stating here that claims of harmful constitutional error are appropriately brought in a habeas corpus proceeding. This petition, this one here, prudently raises facts and issues not previously raised. Subsection 1, ineffective assistance of counsel claims are most appropriately brought in a habeas corpus proceeding. It says New Hampshire has held generally that, quote, ineffectiveness claims are best brought in a collateral attack, end quote, citing Kinney. Quote, an allegation of ineffective assistance of counsel need not be raised on direct appeal and may be raised collaterally by filing a petition for a writ of habeas corpus after the time for a direct appeal has expired, if the petitioner can establish harmful constitutional error, they quote Mallard, State v. Thompson. Quote, under no circumstance shall the failure to bring an ineffectiveness claim on direct appeal result in the procedural default on that claim, end quote. I'm trying to think, are we seeing ineffectiveness of counsel? The first thing is you have to appeal to the next higher court, and then the next higher court, and then the next higher court, and then to go to the Supreme Court, okay, which is appeal. And then we've got habeas. Are they trying to say it's better to just put the habeas or put the ineffectiveness of counsel in habeas, or put it in the lower court appeals to the higher court in the lower jurisdiction? I'm not an attorney, so I don't understand that. Because to me, I think you would want to raise it anytime that you could. What do you think? Rather than waiting. Or they're saying a collateral attack. It doesn't say a consecutive attack. And I don't know, meaning collateral, if that's at the same time. So I'm trying to figure out what they're saying here. Is it best in a habeas petition and then you wait, or you do it at the same time? See, it says after the time for a direct appeal has expired. And that makes me kind of like, why would you risk it? Okay. It says here, claims of ineffective assistance, this is State v. Pepin, claims of ineffectiveness assistance of counsel based on alleged trial errors are not procedurally barred by the failure to raise those concerns on direct appeal. Man, I don't know if I think I would want that sooner rather than later, but I'm not sure. Okay. So it says here, a defendant is constitutionally entitled to the effective assistance of counsel. And yes, I went through the ABA bar standards, talking about expert witnesses. That was in the video for the Lindsay Clancy case. I went through what the bar standards are about the experts and showed there's a whole listing if you want to see that. The ABA, the American Bar Association standards for criminal justice practice for defense and prosecution, and they talk about experts, they talk about the whole thing, and in that it outlines how to be effective counsel. So you may want to look at that video, and you may just want to look at the bar standards, because it's very, very important. It talks about a lot of things. So here the defense says a criminal defendant is entitled to effective assistance from counsel according to the Sixth Amendment of the United States Constitution. They cite Strickland v. Washington. In Strickland v. Washington, the Supreme Court of the United States created a two-pronged test to resolve claims of ineffective assistance. First, the defendant must show that counsel's performance was deficient. ... Second, the defendant must show that the deficient performance prejudiced the defense. For the prejudice prong, the second one, unless in a situation where prejudice is presumed, quote, the defendant must show that there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. A reasonable probability is a probability sufficient to undermine confidence in the outcome. They quote Holland v. Jackson. They say, where both prongs of Strickland are met, quote, the Constitution requires that a criminal judgment be overturned, end quote. They say, notably, the constitutional right to effective assistance of counsel applies even when the proceeding in which counsel assists is statutorily created. Hopefully you can see this here. So this is the Habeas standards, and you can type in American Bar Association criminal defense standards. And they got, look, so many here. The scope and function of these standards, function and duties of defense counsel, continuing duties, right? Now the petition talks about unprofessional. So there's continuing duties. Let's see if we can pull them up with, it's going to keep going. I'm going to go back up here. Functions and duties, continuing duties, tempered duty of candor, truthfulness, preserving the record. That's important. Improper bias prohibited, conflicts of interest, appropriate workload. Man, that comes up a lot. Diligence, promptness, and punctuality, relationship with media, advisory groups, communications for guidance on issues of professional conduct. The petition talks about that. Training programs, got to have adequate training. Assuring excellence and diversity in hiring, retention, and compensation of public defense counsel. Okay, that's your public defenders. Access to defense counsel. I hear that all the time. They never come to see me. They never talk to me about my case. Duty to make qualified criminal defense representation available. Confidential defense communications with detained persons. That sets out standards for their communications, because obviously the state monitors stuff. Right to counsel at first and subsequent judicial appearances. Referral service for criminal cases. Referrals for representation, lawyer-client relationship, establishing and maintaining an effective client relationship, seeking a detained client's release from custody or reduction in custodial conditions, interviewing the client, fees, engagement letter, library or media rights agreements prohibited, writing books, prompt and thorough actions, prompt and thorough actions to protect the client, anticipated unlawful conduct, duty to keep client informed and advised about the representation, maintaining continuity of representation, relationship with successor counsel happens a lot. They don't tell the new counsel. They don't share discovery with the new counsel. The client's file. Investigation and preparation. Duty to investigate and engage investigators. Illegal and unethical investigation prohibited. Relationship with witnesses. Relationship with experts. Compliance with discovery. Preparation for court proceedings and recording and transmitting information. Handling physical evidence with incriminating implications. Control and direction of litigation. Advising the client. Remember, they say, my lawyer didn't tell me that. Control and direction of the case. Obligations of standby counsel. Consideration of collateral consequences. Special attention to immigration status and consequences. Disposition without trial. Plea agreements. Duty to explore disposition without trial. Negotiated disposition discussions. Plea agreements and other negotiated dispositions. Okay, so maybe this other one is diversion. Opposing waivers of rights in disposition agreements. Okay, and we saw that in Carmelo. We saw that in Carmelo Anthony, but it was with regards to testimony that they agreed in the judge's chambers. If you watch that video. Court hearings and trial. Scheduling court hearings. civility with courts, prosecutors, and others, selecting jurors, relationship with jurors, opening statement at trial, presentation of evidence, standard examination of witnesses in court, closing argument, facts outside the record, comments by defense counsel after verdict or ruling, motions for acquittal during trial, post-trial motions and sentencing, post-trial motions. Okay, I could keep on going all the way down here. Conduct, okay, all that stuff. So there's a lot there that you can look at if you want to learn more about were they effective or were they not effective. Okay. New Hampshire state constitution similarly and independently guarantees a criminal defendant reasonably competent assistance of counsel. State v. Sharkey. Part 1, Article 15 of the Constitution of New Hampshire has established a two-part test for determining whether an attorney has provided effective assistance, and this test mirrors the test applicable under the federal Constitution. Alternatively, stating the federal test, New Hampshire has stated that a court must determine using an objective standard whether counsel acted with reasonable competence, and they quote State v. Faraji. For a defendant to successfully assert a claim that the defendant did not receive effective assistance of counsel, the defendant must show first that counsel's representation was constitutionally deficient, and second, that the counsel's deficient performance prejudiced the outcome of the case. And I'm quoting Sharkey. To meet the second prong, a defendant must demonstrate prejudice by showing that there is a reasonable probability that the result of the proceeding would have been different had competent legal representation been provided. Now, just coming to mind, we were also talking about this in the A&E Scott Peterson case. I was thinking about it when we had, I think we say Mark Garagos, is that how you say his name, who was part of his former counsel. He was being interviewed and he sat there, and don't quote me exactly, but I remember him saying something about, we didn't do this because we thought we had it. Like, we thought we had it. Okay, so there was a decision made to not do certain things because they thought they had it. And did that affect the outcome if those things could have been shown? Now, there was a whole other host of issues, but as the attorney of record, you decide who you're calling. Okay, I talk about my chess game or my fight card or my sports analogy or my Netflix show, where you decide who the cast of characters is going to be, who your witnesses are, what you're going to present, what evidence you're going to present, what rebuttal, what experts you're going to present. And you may get it wrong, okay? So it also says here, now she's already done a habeas, okay? Now this is interesting. It says a subsequent habeas corpus proceeding may raise claims of ineffective assistance by previous habeas counsel. So maybe they're asking for what they call a second bite at the apple, saying that the prior habeas team was ineffective. It says a conflict of interest may prevent counsel from properly bringing a meritorious ineffective assistance claim, where trial counsel continues as counsel for a first petition for writ of habeas corpus. Such a conflict is inherent. Okay, so it sounds like they're saying that when the original trial counsel makes the first writ of habeas corpus, there's excuse me, an inherent conflict of interest, right? And we went through the ABA talking about conflicts of interest. Counsel would be forced to claim their own assistance was constitutionally ineffective. New Hampshire recognized such a conflict in State v. Veal. In State v. Veal, this is so interesting. I hope you find it interesting. I think it's so interesting. The court established that the appellate defender and the office of the public defender constituted one firm, and that's interesting, and continued representation on an ineffective assistance claim caused an inherent issue. Typically, You can have someone from the public defender's office, and sometimes the public defender's office has different offices within the office. So they have different groups of attorneys doing different things. And then you typically have an appellate division, but they're usually different attorneys. The way I'm reading this sentence, I'm not sure. It sounds like they're saying that even though the appellate defender was different than the public defender, original attorney public defender, trial public defender attorney versus appellate public defender attorney, different people, it's one firm, which is kind of true, and that it caused an issue. If you think about it, if they didn't have the public defender and they had a regular law firm and one partner did the trial and then another partner did the appeal, that there could be a conflict of interest because they're saying that they're going to claim that things were done wrong, and they're not likely to blame themselves and make themselves look bad, is I think where they're going with that. It says, quote, a public defender attempting to represent a client who has charged that the public defender with ineffective assistance could quite obviously be representing a person with interests adverse to his own. The public defender, instead of advocating fully for the client, might be interested in protecting and preserving his own professional reputation, end quote. And the public defender, even though they're talking about the office, the public defender is the state attorney, the head state attorney, or the head district attorney, or the attorney general, the top one. The public defender is like there's a head public defender, and I think that's what they're referring to there. Like in a private law firm, the managing partner is going to tell, maybe that's where they're kind of getting at, don't say this because this is going to come out in open court and we can't have this on the firm, right? Seen it in the law shows. Excuse me. Okay. The court recognized that the public defender, quote, would likely be hesitant to raise his own trial inadequacies on appeal or even inform the client of any inadequacies, end quote. Now that's kind of nasty there. Or even inform the client of any inadequacies. That's nasty. Again, I just showed you the ABA standards about candor. Inasmuch, quote, that public defender would be forced to withdraw from any case alleging his ineffectiveness, end quote. The court provided thereafter that if, quote, a defendant has raised a claim of ineffectiveness assistance against a public defender and the appellate defender has been appointed as appellate counsel, the appeal will, absent special conditions, be stayed, end quote, so that adjudication of the merits of the ineffective assistance claim can occur in the superior court before resuming litigation of other issues brought on appeal. Which sounds like they're going to send it back to work out the public defender office deal and then move it forward. In extension, when counsel handling a habeas petition fails to bring a meritorious claim, like a winning claim, that counsel becomes answerable for the ineffective assistance of counsel as habeas counsel for not properly bringing a meritorious claim in a first petition. Basically, what they're saying is, when you're a bad trial attorney and you lose at trial, that's the basis. But when you're a bad habeas attorney and you don't get a review or you don't get it granted, you're a bad habeas attorney. Effectively, these circumstances preserve an ineffective assistance of counsel claim for a second habeas petition when they are not properly raised in a first petition. Therefore, new ineffective assistance of counsel claims can be brought in a second petition if those particular claims of ineffective assistance of counsel were not raised in a prior petition. See Mallard. Ms. Smart first contends that her prior, we know what's coming, right? Ms. Smart first contends that her prior habeas corpus proceeding should be considered null due to the Superior Court for Rockingham County lacking jurisdiction to hear and rule on the matter. Here we go again with jurisdiction. Quote, to the Superior Court in the county in which the person is in prison, end quote. In the event the hearing is recognized, it was improper for trial counsel to remain counsel on Ms. Smart's first petition for habeas corpus relief due to the inherent conflict of interest. The petition's failure to raise any contention of ineffective assistance of counsel affirms as much. Ms. Smart was specifically provided ineffective assistance of counsel during her prior petition due to the failure to include the available and meritorious claims brought in this petition. So they're saying that because the first habeas attorney didn't bring up the stuff in this one, they were ineffective, and because it was the same office that did the original trial. Very, very, very interesting, raising a lot of good points. And we're going to continue on this. We're going to see what they tell us. All interesting things, because they not only relate to this case, but they relate to all the cases moving forward, and we get more educated as these issues are brought up so that we can properly evaluate, prepare for, and comment on all the other cases before the court, right? We will become knowledgeable. So thank you for being here. I really appreciate your support of the mission, liking and subscribing, and I will see you on the next one.